All right, this is an interesting case to file. We will be live there tomorrow, and this is something that we want to analyze in its entirety. And we have with us right now somebody who knows Florida law very well, and that, of course, is trial attorney David Pietro. David, welcome back here on Law and Crime. We haven't seen you in a bit.
Long time no see. We're glad to be back.
All right, let's talk about Florida law right now. In general, proving self-defense, is that tough in Florida as opposed to other states?
No, it's actually a little different in Florida. We have what they call the stand your ground law, which basically changes the requirement of fleeing. In some states, you have to show that you use self-defense because you were unable to leave the situation or unable to flee first. So there's a legal requirement that you have to, if you can flee and get out of the area and move to a safe location without having to encounter somebody, then that requirement is needed for self-defense in many states. In Florida, that is not required. You're allowed to stand your ground, and it's more of a subjective standard where you, if under that situation, as it developed, whether you could flee or not flee, were you illegally permissible to defend yourself and utilize deadly force? So self-defense in Florida, it's been somewhat controversial because a lot of police officers have utilized it in police shootings in Florida, and in other cases, it's been a controversial law since Governor Bush put it into play because it's tied with the Second Amendment and the right to bear arms. But it makes Florida unique, and it makes standing your ground a little bit easier in Florida than other states.
Well, look, here you have an altercation between three individuals. And the question, the biggest question, or one of the biggest issues is whether or not Muhammad Knight, the victim, was the aggressor. And one of the ways that the defense keeps showing he's the aggressor is that they said he walked to their car with a beer bottle in hand. And yes, there's a back and forth about whether or not he was actually holding a beer bottle or a red Solo cup. But if we are to take the fact that he's holding a beer bottle, he approaches their car, but he's the one who ultimately is stabbed, and let's not forget this is 2 against 1 here. Is there a way for Armando Baptista to really successfully mount a self-defense argument?
I think so. If the victim in the case was also an aggressor and had the ability to utilize deadly force, and that perception was a real perception, and Baptista used deadly force to defend himself, I think that would create a reasonable doubt as to the intent of the crime because of the affirmative defense alleged, and whether the defense put up sufficient evidence for the jury to hang their hat on that. That's what they're going to have to decide. So as long as the defense can either through cross-examination or through their own testimony and evidence, which they're not required to prove, but they might need to put on their own evidence to keep their self-defense argument. If they can prove that, then there's a chance that the jury, a real chance that the jury, could find him not guilty for reasons of self-defense.
All right. Well, look, we have a lot more to talk about in this case, especially when the defense ultimately takes up their case and whether or not they put Armando Baptista on the stand. We'll talk about that later. But in the meantime, let's take a quick break. When we come back, we're going to change this conversation and talk about Wendy Gonzalez and how her testimony from this trial is different or the same from when she testified in the Demetrius Elder trial. We'll be right back. All right, so let's break this down right now, back with David Pietro. David, my question to you is it so strange to you that you have a witness who testified in 2 different trials? One was in July, one was now, not that far apart, and her testimony is different. Yes, I mean, her manner is different, her composure is different. She seemed to be much more emotional this time around. And we can't forget the fact that in that first trial with Demetrius Elder, he was found guilty of culpable negligence, not manslaughter. So do you think the prosecution coached her differently? Do you think she changed something differently? Or is it just a matter of this is human nature, it's 2 different testimonies?
Or it could be an element of all the above, right? So she could have been more emotional, less emotional for various reasons, and with things going on in her own life. And that's the interesting thing about testimony is the way we remember things over time changes. I mean, just think about how we remember our childhood. The way we remember our childhood probably wasn't exactly how it happened because it's so many years away. The way we perceive things over time and the way the brain and the memory works things can change. They shouldn't radically change, but they can logically change, not because someone's being untruthful. It's just two people can see two different things differently, and over time they might see it even more differently. So, but that's hard to argue to a jury. Juries, they don't like inconsistent statements. It's in the jury instructions. That's one of the things they can consider is prior inconsistent statements.
Well, one of the benefits of watching Law and Crime and not sitting on that jury is that we get an opportunity to see her testify in those two different trials. The jury here won't get the chance to see that. But I want everybody who just saw that, is it fresh in your mind the way she just testified? Well, this is how she testified in this trial. Take a look. Okay, so David, look, you know, it's impossible to know what it's like to be Wendy Gonzalez, whose boyfriend was stabbed to death, and she was right there. So it's impossible to understand what her emotions are. But you see what I mean, that there's a little bit of a different demeanor here, right? I mean, she was very emotional this trial, and the last trial she was very cool, calm, collected, clear. But is that also a consequence of maybe the way she was questioned by the attorneys? It was two different attorneys questioning her.
It could be that, and you know, it changes time. It goes from anger to sorrow. So she might be going through her own loss cycle right now, where her emotions are at a different level and a different stage. That make it perfectly logical as to why some of her demeanor and mannerisms are different from one point in time to another.
Do you think, though, it's fair? Well, let me rephrase. We saw a little bit of the cross-examination of Ms. Gonzalez earlier. How tricky is that for the defense attorney to question this woman whose boyfriend was ultimately stabbed to death? I mean, that's a tricky balancing act. You have to be careful because you don't want to say or do something that looks bad in the eyes of the jury, right?
Right. You got to know where you're picking your pieces apart. What parts of her evidence are you going to use and derive from her testimony to your defense without offending or shocking the conscience of the jury that you're just a rude, mean, ugly lawyer that beats up this poor woman who's suffering. So that's a balancing act. And I've seen lawyers do it, and it's apologizing, so to speak, for your loss, but saying that their client's not legally responsible. So there's a way of saying this is something really horrible that happened, but doesn't mean that the person on trial is legally responsible for it.
Yeah, that's a good point. Listen, let's take a quick break. When we come back, we have more to talk about in this case, and you know where I'm going next. We've got to talk about the bottle versus the red Solo cup. We'll be right back. Okay, let's break this down, this beer bottle Solo cup distinction. I'm going to bring back on David DiPietro, our trial attorney, but also we got another special guest with us here on set, criminal defense attorney and former prosecutor, Mike Koribanics is with us. Mike, great to see you again.
Great to be here.
Looking sharp as always. All right, let's talk about what we just heard from Wendy first. The idea of, okay, you know, he doesn't drink beer, he likes vodka. I didn't really see this beer bottle. It's really focusing on the red Solo cup. Do you see something awry here? You see something, there's an issue coming?
I think there's always an issue coming whenever you have such conflicting testimony, and it just seems that, you know, now she's stressing him not drinking beer, drinking vodka to sort of draw attention away from the beer bottle. So I guess the inference there is that if he was drinking vodka, he wouldn't have a beer bottle. But this red Solo cup is like found a little bit further from the scene. It's a very common sort of piece of garbage you'd see laying around, but a broken beer bottle so close to the scene, I think, presents a problem for the prosecution in this case.
David, you're our expert here on Florida law. Let's just assume that Muhammad Knight really did have a beer bottle. Let's even say it was a broken beer bottle. Would you say a knife, the one that was taken out and ultimately used to stab him, would be a equal amount of force to be used against that beer bottle? Do you see what I'm saying here? Even if we assume he was carrying it, would it justify using a knife?
I think a beer bottle and a broken beer bottle are two separate instrumentalities, right? So a beer bottle, you could break it over someone's head, which isn't really deadly force. A broken beer bottle with jagged edges could be used to perforate the skin and cause serious bodily injury or death. It's not, you can use deadly force in Florida, not just because someone's going to kill you. If they're going to cause serious bodily injury, that's a basis to use deadly force. So I think a bottle broken and not could have a distinction, but I think a bottle it would be sufficient at the end of the day.
Well, look, there's a lot that we just don't know yet, and I think there's a lot that we're trying to figure out because we seem to have more questions than we do answers. And again, we are waiting to see whether or not Armando Baptista will take the stand and try to explain some of this. We saw his interview with the DA. We'll talk about that in a minute, but let's take a quick break. When we come back, a lot more to discuss here on Law and Crime. All right, let's study how that cross-examination was. I'll start with you, Mike. What do you think? How did they do at pinpointing certain discrepancies in their testimony, certain things that didn't sound so right?
Yeah, this cross-examination, he's making some points on cross-examination, but it seems like he's giving the witness a little too much time to, like, go further in her answers. I always like a cross-examination when there's inconsistencies, where the attorney pinpoints the inconsistencies with very short answers. I think he's losing some rhythm by letting her go on and on with her answers. They should be yes or no kind of answers.
David, what do you think? You think there was any points made by the defense, or did it ultimately look like she was a very strong prosecution witness, from what you've seen?
I think Mike's right. No pun intended, but cross-examination is like a knife fight. You got to get in and get out of there. You got to make your points. You almost need to already know the answer to the question, or you want to be able, through your questions, to insinuate facts. But when you give witnesses leeway and they're adverse witnesses, they're going to circle back around and make sure their testimony fits the picture and the theory that they're pushing.
And like I said, what we can analyze, and not the jury, is we're not just seeing how she did under direct and how she did under cross, but also how did her testimony now match up to how it was back in July. So it's an interesting perspective for us and trial watchers here on Law and Crime. But what we're going to do is we're going to take a quick break, and we have to ask some other big questions, including whether or not the defendant, Armando Baptista, should he take the stand? Let's talk about it when we get back. All right, welcome back, everybody. Let's talk about what we just saw. I'm back here with Mike Koribanics. Mike, my question to you is, you heard that, raising some interesting issues there about why they never moved the car, why he thought he was justified, didn't really even know the victim that well, thought there was some sort of grudge. I'm curious your reaction after listening to that.
One thing that's always bothered me about this case has been the positioning of the cars. It just doesn't seem logical that Batista would be in front of the other car that had Muhammad, and Muhammad gets out and goes to the car in front of him. And that always seemed to me to be the most aggressive part of this case. And also the fact that his girlfriend basically confirms that he got out of the car first. And I think that's going to be a problem for the state in this case, because it appears he obviously was the aggressor. And here he is, Batista, the passenger, he says in his statement, and he has no control over the car. They just have to deal with this surprise attack, for lack of a better word. So I think it's playing into their benefit for the self-defense.
David, you're listening to this as well. They weren't charged with murder. They were both charged with manslaughter. Demetrius Elder was ultimately convicted of the lesser charge of culpable negligence. Correct me if I'm wrong, I think manslaughter carries 30 years in prison. What do you think the jury held on to in that Demetrius Elder case and said, you know what, this isn't really manslaughter, this is culpable negligence? And if that's the case, what do you think the prosecution needs to do differently this time around with Armando Baptista?
So manslaughter carries a 15-year, it's a second-degree felony. So culpable negligence is a third-degree felony, which would carry up to 5 years in Florida. So really, I think what they need to harp on is the actual jury instructions and what elements they actually need to prove and that they're trying to derive. So for manslaughter in Florida, you have to prove that the defendant intentionally committed an act or acts that caused death, intentionally procured an act that caused death, and the death was caused by culpable negligence of the defendant. So I think they really need to harp on that the intent was to cause death. It wasn't a self-defense, and it happened at that moment. It wasn't something thought out like a second-degree murder or a first-degree murder. There was less a forethought in going into it, and really it was the act and the commitment and fulfillment of the death and the actions that were amount to the level of manslaughter. So that's what they should really harp on, that they don't need to prove this intent side of murder, or that they need to prove that he intended to do it.
Sounds like I'm back in law school. That was a really good explanation about what this is. But if you're sitting on the jury, Mike, I got to ask you, how do you sort this out? I mean, it really sounds like an altercation where nobody's clear about what actually happened.
Well, by its very nature, if nobody's clear about what actually happened, then they must acquit if they're going to live up to their oath, because obviously they haven't proven anything beyond a reasonable doubt, and that plays to the defense's, right into the defense's hands.
All right, well, maybe that's the case. Maybe they'll find him not guilty, maybe guilty of culpable negligence. I don't know. We'll have to see. All right, let's take a quick break. When we come back, obviously there is more to discuss in this trial. We'll be right back. All right, so when he was in custody, he provided these statements to authorities. I'm back here with trial attorney David Pietro to break it down. David, you're listening to this. Classic set of facts is saying self-defense. I was minding my own business when I got attacked, and I did whatever I had to do to protect myself. That idea, what you just heard, how do you think the jury's thinking?
They could believe it. It could be believable because it's right after the incident happened, so it's not a long period of time to concoct a story. I think given that his statement was admitted in the trial, I wouldn't have him testify because I think it can only hurt. Had he not given a statement, he had to give his story in order to get the argument for self-defense, then he might have to testify. But under this circumstance, he does not want to be subject to, most lawyers don't want their clients subject to cross-examination. It, more times than not, is more harmful than helpful.
David, you make a good point, but Mike, I'm curious from your perspective, the idea that maybe you gain something from having the defendant testify right in front of that jury that maybe you don't always get in that police interview.
My cautiousness tends to agree with David is, you know, you have the statement. That's every lawyer's dream, to have a statement that's believable, that's close in time to the event, to go in front of the jury, that's not subject to cross-examination. You can argue the facts. Now this is where good lawyering comes in your summation, because you actually have the facts to hammer to the jury to show that how your client acted in self-defense without having to go on the stand. Although always a jury, I think, regardless of the instruction, it's in the back of their head, but you really need to make the real practical call here and the safe call. You're already up. You can only go down by the, you're not going to improve much by putting your client on the stand in this instance.
Look, at the end of the day, we're talking about the defendant's statement one way or another, and in case you missed it, this is more of the police interview from Armando Baptista where he gets into the specifics of the actual fight. Let's look. Okay, David, we're still learning more about this fight, and it seems like a classic example of self-defense. Where do you think there were parts that the prosecution was trying to get there? Because remember, this is still their case. They put this into evidence. What do you think they gained from putting this forward?
That's what I'm scratching my head as to why they put it into evidence, because if you want a defendant to testify, by putting his statement into evidence this way, you're the only party that can put it in. They can't put it in evidence. It's self-serving hearsay. So they had the prosecution had to put it in. So I'm trying to figure out what nuggets they're pulling out of it, because the crime is self-explanatory. So why they put the statement in, I'm not quite sure.
Mike, what do you think? I mean, was it the idea, let's try to get under this before it becomes an issue? Hey, we know about this self-defense argument, okay? We know about this, guys. Let's put it in forward and we'll talk about it then. I
don't know. If I'm the defense attorneys, this is like manna from heaven. Like, I agree with David. I don't know why they put it in. I can't see what they're going to pull out of it other than the fact that now they've put the defense in without having the defendant have to take the stand. And that just seems very contrary to a good prosecution.
Especially if they're saying that we made some mistakes with the Demetrius Elder case. We didn't get him guilty of manslaughter. We got him guilty of culpable negligence. What did we learn from that trial? So it becomes a question. Listen, we'll take a quick break. When we come back, obviously more testimony to discuss because we will be live back in this trial tomorrow. We'll be right back. All right, David, my question to you is this. Armando Baptista says he didn't leave the car. She says he did leave the car, and that's where the whole altercation happened. Now, you might not think that's a big difference, whether or not he exited the car or not, but it really is. And the idea here about who to believe and what really happened is huge here. So if I'm sitting on the jury, what am I supposed to do?
Well, she's been, all the testimony you've played to your audience, she's been 50-50 on the details. Like some things she remembers and some things she didn't see. So I really think somebody should ask her where she was in proximity and really get her vantage and visual point, because I don't know if she was able to see everything from what I've heard so far. So I'd be questioning not whether she's being truthful, but whether she was in the best position to provide the best evidence for this issue.
What are you talking about? A little like my cousin Vinny, how far away you were? I get it. I get what you're doing there. It's a classic example. Now, Mike, my question to you is, based upon the physical evidence that we've seen, and I'm talking about the crime scene and the examination of the car, we talked a little bit about the glass and the blood being present. What backs up which story better? Does it back up what Armando Baptista was saying about being attacked in the car? Or could it also be very plausible based upon the evidence that we've seen, Wendy Gonzalez's testimony?
Well, I think it favors the defense, the evidence here. The evidence produced, the glass in the car, the blood in the car, that's objective evidence that really goes to the heart of the self-defense. And also, the one thing that bothers me, like I keep saying over and over again, is the car's positioning of the prospective parties. But not only the respective parties positioning the car, but the fact that why is this guy, who doesn't really know him, getting out of the car, Muhammad, to go to the other car to say hello and greet him with a red Solo cup? That is, that's a weak foundation to build everything on your prosecution, because it doesn't make sense.
David, what does make sense? The idea that they really didn't know each other, but then there was this kind of feud. I mean, what makes sense about what ultimately happened here? So let's break it down. I mean, really, what story makes sense to you about why this all unfolded? Is it two people that were aggressive and didn't like Muhammad Knight coming up to their car? Or was Muhammad Knight aggressive the whole night, and that was just another example of him getting ticked off and didn't, he was waiting at a stop sign? I mean, what makes more sense to you?
I think right in between, in the middle, that probably they were both aggressors and one guy lost. So the question is, the guy that won, can he claim self-defense legally? So I think this was a hot-headed situation that got carried out of control. And the question is, from a legal standpoint, will the self-defense work? And I think there's a heck of a shot that it will.
And at the end of the day, we can't forget how tragic this is. We are talking about someone whose life was lost. There was a result of what? A fight? For what reason? I don't know. It doesn't make sense. Let's take a quick break. When we come back, a lot more to discuss. Okay, we need to talk. First, I'm going to bring on Mike Koribanics to talk about it. Okay, so those were three witnesses. Well, if you want to say his police interview was an important piece of testimony. Those three clips that we played were really important for the defense. Would you agree? Was there anything that really stuck out for you?
Something's been bothering me about this case, and I've discussed it with you before, is the fact, like, these are crime scene technicians. And, when your crime scene technician says, I don't recall if I saw blood, that sort of sends a subliminal message to the jury, in my experience, that, they're there, they have a first impression of the case. Obviously, she didn't care enough or think it was that big a deal that these kind of things that would stick in your mind, like blood in the interior of the car, that she just thought that this was some fight and who cares what happens to either of the people. That's the impression I get with it. This is a crime scene technician. I mean, they should be prepped for the trial. I don't recall if I saw blood is something I'd be talking to about with the jury.
Yeah, it raises your eyebrow a little bit. But David, I mean, from a real content perspective, what she said was important, and so was Detective Zeller and also the Baptista interview. The fact that there was this glass in the car seems to support the defense's theory that this was, in fact, self-defense, and he never left the car.
Yeah, I agree. And this testimony of this technician is shaky at best. The problem with Broward counties, this is where I was a prosecutor, is a lot of there's 31 cities, and a lot of these cities, even though it's a metropolitan area, maintain their own crime scene attacks, and it's not done like in bigger areas like New York City, where you'll have somebody who's more experienced and works throughout the whole city in the metropolitan area. So this might be her first time on the stand, for all we know, and she might be nervous and shaky, and it's not turning out well.
Well, listen, what I do know is that both of you were great guests today. So, Mike, thanks so much for coming on. David, thanks so much for coming on. We can't wait to have you both back to talk about this. Now, Ladies and gentlemen, we have to tell you, tomorrow at 10 a.m., we expect our live feeds in 2 trials. Yes, we're going to continue the Armando Baptista trial, and we are also going to be live in the Nicholas Godejohn case, the man who's on trial for allegedly murdering his girlfriend's mother. Pretty unbelievable case with a lot of moving factors. Now, here on the network, we're going to be closing up shop, but that's okay, because up next is the Daily Debrief with our very own Aaron Keller, so you want to stick around for that. And we will be back here 9 a.m. for the Law&Crime Network. Thank you, everybody. It's been a great day, and stay tuned. We'll be right back.